How are you today? So today's discussion, and this goes back to July of 2020 in regards to what we're talking about, but it's really applicable because we have so many leases that were originated well before that date. It's very interesting. So we need to understand what's happened not only in the past, but what's happening currently. Right? So we're going to talk about the statewide rent cap and just cause eviction law. Now, that term is interchangeable. It's also known as the Tenant Protection Act, and it's associated with Assembly Bill 1482. So it's kind of a generic name, and we hear similar things to that. But if you hear Assembly Bill 1482, the TPA or Tenant Protection Act, or the statewide rent cap and just cause eviction law, they're all the same thing. So I want to go over a quick summary of these different aspects. So in the name, statewide rent cap, so there's two aspects of the law. First of all, in regards to how much rent you can charge somebody, and then the other aspect, just cause, it's associated with terminating a tenancy. So two distinct aspects, as a matter of fact. So the rent cap, assuming a landlord is subject to the Tenant Protection Act, and everybody is subject to the Tenant Protection Act, unless they exercise an exemption. So keep that in mind. We're going to talk about the form RCJC. This is a way to exercise the exemption. But rent caps, if you are subject to the Tenant Protection Act and you do not check this box for a notice of exemption when providing the RCJC, you're limited to a rent increase of 5% plus CPI, but in no case can you exceed 10% annually. We'll go into details of that also. Just cause. Now, if the landlord is subject to the Tenant Protection Act and has not exercised their exemption, there's a list of 15 reasons that they must use when terminating a tenancy. So there's at-fault terminations of tenancy, so non-payment, damage to the property. Then there's also no-fault termination of tenancy. And that would require, if it's a no-fault reason, so for example, I want to move my daughter into this rental, that would require me to pay 1 month's relocation assistance or write that tenant a check. We'll go into the details of that also. And keep in mind that just cause eviction rules only apply to tenants who have been continuously and lawfully occupying the property for 12 months. So lawfully is a key question. Exemptions from rent cap and just cause. So on this form, we're going to be using this. It's part of the lease agreement, as a matter of fact. But single family properties are exempt. Remember, you have to take advantage of the exemption. However, if the property is owned by a real estate investment trust, a corporation, or an LLC in which at least one member is a corporation, the exemption may not be available to them unless the property is 15 years of age or newer. So a lot of the apartment buildings that the Irvine company they're building, if there's a certificate of occupancy and it's no older than 15 years of age, that's an exemption for them from the Tenant Protection Act. Duplexes can also be exempt. We'll go into the detail of that. And this is interesting to me. Dormitories, so you think about colleges, they're not subject to rent cap or reasons for termination of tenancy. And then also owner-occupied single-family properties renting no more than 2 bedrooms, including accessory dwelling units. And ADUs have become a real issue, not an issue, but something that's very, very common. And the law does not apply to commercial properties. Does it apply to vacation rentals? Theoretically, it's not stated in the statute, but it really is not applicable, just so you're aware of that in case somebody questions you about that. And the law does sunset January 1st of 2030, but my guess is the state legislature will probably extend that before the expiration, as a matter of fact. So what do I need to provide my tenant? You need to provide them when signing a lease. They can't see the top here, Carlos. The rent cap and just cause addendum. As I said, it's part of the actual packet when signing a lease agreement. And prior to July 1st of 2020, if there is a lease agreement in place, you could have just provided this form as a notice, and it would have been applicable. But subsequent to July 1st of 2020, if you haven't had this signed and there's an existing lease agreement, you can't just hand it to them and it's not enforceable unless they voluntarily agree to sign it also. So if the owner has not had a tenant sign the form, or maybe there's an error that the exemption box was not checked, have they forfeited their rights to invoke the exemption? No, but they have to provide the form, as a matter of fact. So if it's a month-to-month tenancy, it's still applicable. So you need to be sure that this is signed. If it's a month-to-month tenancy, the tenant may not agree to voluntarily sign. So that's an issue. And there are methods that you can use to enforce this form within 30 days, kind of just like arbitrarily increasing the rent on a month-to-month tenancy. So what about actual lease agreements? If I have a lease agreement in place and this form is not signed, can I just arbitrarily send that to them? And what if they refuse to sign? There's nothing I can do until lease termination, as a matter of fact. If they voluntarily sign, then we can incorporate that into the lease agreement. Once again, even though the owner may be entitled to the exemption, if we don't have the form completed properly, the owner is not entitled to the exemption. And what if the tenant refuses to sign? And I want to get back to one other thing. Sometimes leases are sent out, and often, not often, but what I've seen witness cases in which we have the landlord sign the lease agreement and all the documentation prior to the tenant signing. Please don't ever do that. Because if they sign that and the tenant doesn't sign the RCJC form, it's not going to be a part of the lease agreement. So always have the tenant sign those documents prior to the landlord signing. What about the method of signing? So if we have a lease agreement, we can have both the tenant and landlord sign electronically. That's entirely permissible. But if we're on a month-to-month tenancy and we want to incorporate the RCJC into that month-to-month tenancy, how can we do that? Well, we can attach that form to a notice of change in terms of tenancy. And that's no different than a rent increase, because if it's a month-to-month tenancy, we can send notification to the tenant with a 30-day notice that we're increasing the rent. And we can do that arbitrarily on our own without their permission, as a matter of fact. So we would always be using a notice of change in terms of tenancy. Now, the difference is going to be when you send out a notice of change in terms of tenancy and attach that as the RCJC or a rent increase, it must be signed by hand. It cannot be signed electronically. So any notice that is sent to a tenant that's enforced within this 30-day time frame cannot be signed electronically. It's not enforceable. Yes.
So you said that's for month to month. What if it's in the middle of a lease and they want to incorporate this? Do they have to wait till the end of the lease term?
They do if the tenant refuses to sign the RCJC form.
You can't just send the notice of change of terms of tenancy?
No, you cannot. So if it's an existing lease agreement, say a 1-year term, 6 months have passed, we never had the RCJC signed, and we want to take advantage of the exemption, we cannot just arbitrarily change the terms of any lease. Just like changing the rent. We can't just change the rental amount.
But if they're okay signing, then they just sign.
It's perfectly acceptable, right? If they agree to sign, that is correct. So we're going to talk about the rent cap. Once again, this is assuming the landlord hasn't taken advantage of the exemption, or the exemption is not even available to them. So for example, maybe a triplex. A triplex is not unless it's 15 years of age or newer, the exemption is not available to the landlord. Or fourplex, same thing. Duplex, it can be available to somebody. I'll go through the details of that. But in regards to raising the rent, remember, if you're subject to the Tenant Protection Act, it is 5% of the lowest gross rent charge during the previous 12-month period, plus CPI. And CPI is actually published. So we actually can look at a schedule, and we're going to show you that so you know exactly how much you can increase the rent by. But in no case, if you're subject to the Tenant Protection Act, can you increase rents by more than 10%. And then also keep in mind, there are moratoriums on rental increases. So for example, I think that there's probably still one in Pacific Palisades. If that's invoked, and let's assume it's invoked for a 4-year time frame, over that 4-year time frame, you can't increase rents by more than 10% over the entire 4-year time frame. Talk about a burden, huh? Yeah, it really is. And now the CPI schedule we're going to be looking at when talking about how much we can increase rents, it's based upon a period from April to April, which is very interesting. So rent increases are divided into 2 categories: increases that take effect before August 1st of any calendar year, and increases that take effect on or after August 1st. Could you bring up that schedule, Carlos? So for a rent increase that takes effect before August 1st of any calendar year, the CPI percentage will be calculated using the percentage change in the amount published for April of the immediately preceding calendar year and April of the year before that. So we're going to simplify that, as a matter of fact. So if you're subject to the Tenant Protection Act and we're in Orange County, the CPI for this period, if you're increasing rents from August 1st of 2024 through July 31st of 2025, you could not have exceeded 8.9%. And that 8.9% is cumulative. If you're subject to the Tenant Protection Act, you cannot increase rents by more than twice a year. And it's based upon the lowest gross rent over that preceding 12-month period. So that's another aspect. Is if I increase rents by say 5% at 6 months, and then at the end of 6 months, I want to increase the rents by another 5%, or say 3.5% or 3.9%, cumulatively, I've exceeded the 8.9%. Right now, for a rent increase from August 1st of 2025 through July 31st, the cap is 8%. So CPI has gone down slightly. What was that now?
What was CPI stand for?
Well, what they're talking about a percentage change from April to April. So
Cost price index?
yeah, consumer price index. I'm sorry, if that's what you're asking.
Yeah.
Thank you. So right now, so let me ask everybody a question. If you are exempt from the Tenant Protection Act, is there a limit in regards to how much you can increase rents? There is no limit in regards to how much you can increase rents if you're exempt from the Tenant Protection Act.
That's depend on the county.
Well, let's say Los Angeles, I think properties built in 1979 or prior to that, there are restrictions, and I think it's 4%. So based on local moratoria or guidelines, that can actually then obviously that will dictate. Likewise, in Los Angeles, because of these properties built in 79 or prior to that, anything that is more burdensome is going to supersede the Tenant Protection Act also. And then once again, if we were to look at a prior 12-month period, this 8% is based upon the lowest gross rent. Now, the current lease agreement actually has an area that states the lowest gross rent, but the lowest gross rent could be comprised of different things. It could be I'm paying for storage, so on and so forth, but you must state whatever the lowest gross rent is. And it could be 1,000 plus 1,500 plus 17 plus 250, which would be $1,750. Just as long as you state that that is the lowest gross rent, it could be comprised of all these components, then your increase can be based upon, in my example, the $1,750. What if a landlord does not increase the rents over 12 months? Can they bank the rent increase? The answer is no. And then once again, if you're subject to the Tenant Protection Act, can you increase the rent as often as you want? And the answer is no. Over any 12-month period, you cannot increase rents by more than 2 times. And then keep in mind, because the rents are cumulative, you have to weigh that when giving a notice. So if we're going to increase rents by 10%, let's assume we're not subject to the Tenant Protection Act, we're going to increase rents by 10% or less, a 30-day notice is required. assuming it's a month-to-month tenancy. Even if it's a long-term lease, we should be following the same guidelines. If the lease is expiring in a month, we want to increase rents by 10%, we should be giving that an opportunity of a 30-day notice to that tenant. And if we want to increase rents by more than 10%, it's a 90-day notice. So what if we have a tenant that really just wants to extend, or they need another month, something like that, after the expiration of their lease? Don't allow it to go on a month-to-month tenancy, because if you do, thereafter, for you to terminate that tenancy as the landlord, if it exceeds more than 1 year, you're going to have to give them a 60-day notice to terminate the tenancy. So if you're going to allow a tenant to stay 1 more month beyond that initial 1 year time frame, modify the lease agreement. Just add 1 month to it, so the lease will expire. And then vacancy decontrol, that means if any existing tenant has moved out, the landlord can change the rent to anything they want, whether they're subject to the Tenant Protection Act or not. Okay. And then, can a tenant waive their rights? No, they cannot waive their rights, as a matter of fact. Let's see. And then if a landlord gets clever, and assuming they're subject to the Tenant Protection Act, can they put in a series of rent increases built into the lease agreement? Well, they can, but in no case can it ever exceed the maximum percentages that we're talking about. And now, once again, properties that are exempt from the rent cap. Separate alienable units, for example, a condominium or a single-family home, providing that it is not owned by a real estate investment trust, a corporation, or an LLC, in which at least one member is a corporation. If the housing has been issued a certificate of occupancy within the previous 15 years, the exemption is available. A duplex has eligibility. However, if I own a duplex and it's currently tenant occupied, both units are tenant occupied, one tenant moves out, I move in, that exemption is not available to me. It's only available to me as a landlord if I occupy one of those units first, and then a tenant moves in subsequently thereafter. And then keep in mind, triplexes and fourplexes do not have eligibility unless they're 15 years of age or less. And then, interestingly enough, housing restricted by deed for persons and families of very low or moderate income. So that's not subject to the Tenant Protection Act. We talked about dormitories. And other forms of rent control. If it's more burdensome or more restrictive, then that will supersede the Tenant Protection Act. So a couple of other things. So if we talk about separate alienable units, it usually refers to single-family properties and condos. However, co-ops and TICs are likely subject to the rent cap law. And just in case you're not aware, a TIC is commonly used for multi-unit buildings where individual buyers each own a percentage of the building, but they're assigned a specific area to occupy. You see more of that in Los Angeles, as a matter of fact. But then the phrase residential real property that is alienable separate from the title to any other dwelling unit, although it generally includes single-family properties, it does not include a single-family property where portions of the property are rented out separately to individual tenants. So somebody has a single-family property, I'm seeing more of this, and they write lease agreements to 3 different people, then the exemption is not available to them. Yeah. And then the notices. So if we're signing a lease, an entire lease agreement electronically, both parties can sign electronically. If we're going to change or modify the terms of a month-to-month tenancy, we would have to send a notice of change in terms of tenancy and attach to that the rent cap and just cause notification. Or if we want to increase rents, once again, we would attach the rent increase to a notice of change in terms of tenancy, and that must be signed by the landlord. And when sending a notice of change of terms of tenancy, it does not require the signature of the tenant. It will become effective 30 days following delivery and then receipt of that first month's rent. Then also, what if the tenant refuses to sign the RCJC? Well, a landlord has two options if the exemption is available to them. They can allow it to go to a month-to-month tenancy. And then after the expiration of the lease, they can send a notice of change in terms of tenancy and attach to that the RCJC form with the exemption box checked. Or the other option, if a tenant refuses to sign it, that is another reason for termination of tenancy or eviction. You may not want to do that, but those are options that are available to you. Let's see. And then I just wanted to share with you the civil code because we talk about changing unilaterally the terms of a month-to-month tenancy, and that's based upon Civil Code 827. And that states the notice when served upon the tenant shall in and of itself operate and be effectual to create and establish as a part of the lease the terms, rents, and conditions specified in the notice that the tenant shall continue to hold the premises after the notice takes effect. So in other words, 30 days after a notice to change of terms of tenancy is served and after acceptance of rent, the terms of the notice will be treated as part of the lease. So if I own a single family home and with an ADU and I live in one of the units, can you claim the duplex exemption? No. So if I live in one and I have an ADU, I cannot claim the exemption in regards to rent cap or just cause. Questions about that? And then there are some differences between the rent cap and just cause. Remember, rent cap, that's kind of self-explanatory. Just cause, those are the various reasons if you're subject to the Tenant Protection Act under which you can terminate a tenancy. So they pretty much mirror each other. I won't go into the details of the minor differences, as a matter of fact.
Rich, if someone's renting out a room in their home,
Mm-hmm.
there's a lease agreement. Are they not exempt?
They're not subject to just cause, meaning termination of the tenancy. But yes, they very well could be subject to the rent cap. And then if the landlord is subject to the Tenant Protection Act, they just cannot terminate a tenancy at will. If I'm not subject to the Tenant Protection Act, I've taken advantage of the exemption, and I don't want to renew a lease agreement, or I don't want to continue with a month-to-month tenancy, I don't have to give a reason. But if I'm subject to the Tenant Protection Act, there's only 15 reasons of which you can terminate a tenancy. Or actually, you may not even be able to terminate the tenancy, even though you don't like them. Yes. And then what if an additional tenant is added before 24 months? Does just cause apply? Well, it depends. If all the tenants have occupied the property continuously and lawfully for 12 months or more, then it applies. Or one or more of the tenants has continuously and lawfully occupied the property for 24 months or more. If I have a tenant that's occupied the property for 10 months and knowing the exemption is not available to me, am I subject to the Tenant Protection Act? No. It's for a tenancy of 12 months or more. And then what constitutes just cause under the Tenant Protection Act? Remember, I said there's 15 reasons, only 15 reasons that you can use to terminate a tenancy. Non-payment of rent. So there's at-fault reasons, for example, non-payment of rent, a breach of the lease or material term, using the property for unlawful purposes, criminal activity, refusal to allow entry, waste, assigning or subletting the property. Let's see. If the tenant refused to sign a lease renewal with terms similar to the formerly expiring lease. And then if a tenant is actually an employee of an employee is occupying something that their employer is providing, they're not subject to the Tenant Protection Act also. And then also if a tenant serves notice of termination of their tenancy and they fail to vacate, they are not, the Tenant Protection Act does not apply to them. Now, if I'm subject to the Tenant Protection Act and I want to terminate the lease, there are 4 reasons that are considered to be non-at-fault or no-fault reasons. So owner occupancy, where I'm going to maybe occupy it or somebody associated with my family is going to occupy it. I'm going to withdraw it from the rental market. I'm going to substantially remodel the property, or if there's a government order to vacate the property, that is considered to be a no-fault reason. And in all of those cases, if I'm subject to the Tenant Protection Act, I'm going to have to do one of two things. When I serve them notice of termination of tenancy, I'm going to have to give them notification that the last month's rent and the actual amount of rent is going to be credited to them. They don't have to pay it. Or within 15 days of serving that notice, I have to write a check to them for 1 month's rent. And if I don't do that, the termination of tenancy is defective. And let's just go over certain notice periods, as a matter of fact. What does current law require in terms of the time periods necessary to terminate a tenancy, and which type of notice are we to use? Well, it depends. For non-payment of rent, a 3-day notice to pay rent or quit. And this is still an exemption that's hanging out there. And I don't have a specific answer, but if the property is secured by a federally backed mortgage loan, then a 3-day notice to pay may require a 30-day notice to vacate. That's a possibility. So if you're going to assist somebody in regards to terminating a tenancy and there's a federally insured loan on the property, make sure that the attorney who is managing the unlawful detainer action is fully aware of that. So for a nuisance, it's a 3-day notice to quit. For failure of a tenant to vacate the property after they said they're leaving or they terminated their tenancy, there's no notice required. If I'm going to allow or have one of my relatives move into the property, it's a 60-day notice. And remember, I'm subject to paying 1 month's rental assistance or relocation assistance, or crediting the final month rent to them, as a matter of fact. And then withdrawal from the rental market, it's a 60-day notice. And then substantial remodeling, it's a 60-day notice. Now, if I'm terminating the tenancy and I'm subject to the Tenant Protection Act, if I'm not subject to the Tenant Protection Act, I don't have to give a reason. But if I have to give a reason because I'm subject to the act, I want to just go over a few of these things. It's a real burden if I'm going to have a family member move in. So here's what somebody must do if they're going to have a family member move in. The owner must identify in the written eviction notice the name and relationship to the owner. The owner or their family member would have to move in within 90 days after the tenant vacates the property. The owner or family member could not already occupy a unit, and there cannot be another vacant unit at the property. So there could be multiple units, for example. If the intended occupant does not actually occupy the property within 90 days or use the property as their primary residence, then the owner has to extend the tenancy back to the former tenant. And if they choose to elect to not proceed, then when the owner, for 1 year following the termination of the tenancy, they have to offer the property at the rental rate that the former tenant was paying. So you can see how important this rent cap and just cause notice is. Let's see. And then substantially remodeling the property. This is crazy. If it's going to require a term of more than 30 days that the tenant has to vacate the property, then you're going to have to provide a description of the remodel, a copy of the permit or permits to undertake the substantial remodel, a notification if the tenant is interested in reoccupying the rental unit following the remodel. So once again, rent cap and just cause, that form is very, very important. Let's not get into the position of selling something that is not true. Does everybody understand the aspect of the relocation assistance if you're subject to the Tenant Protection Act? Somebody want to repeat that for me? I'm subject to the Tenant Protection Act. I'm going to terminate the tenancy. As a matter of fact, did we put notice of terms of tenancy?
Yes.
Termination of tenancy on there? Okay, great. So on this form, let's assume the tenancy is not covered by the Tenant Protection Act. We're going to check that box, and let's go down to section 3. This is for rent increases, so this is not the same form. That's okay. Do we have determination of tenancy?
Yes.
Okay. All right, so the termination of tenancy, if we're covered by the Tenant Protection Act, meaning we haven't taken advantage of the exemption, we're going to have to actually fill in the amount of the rent that they're going to be credited, as a matter of fact. And we have to give them, remember, we're subject to the Tenant Protection Act. We always must give them one of the 15 reasons why we are terminating the tenancy. If we're not subject, there's no obligation to give any kind of notice or reason why you're not renewing the tenancy. And then let's assume we just don't like the tenant and we're subject to the Tenant Protection Act. Can we not renew the lease? If we don't have one of the 15 reasons, let's assume they've always paid their rent on time, or we're not going to move our family member in, or we're not going to substantial remodel, or the government hasn't said that we have to vacate the property, you may not be able to terminate the tenancy. But that's not true if you're exempt. Really quiet in here. So I just want to remind you, when you're working with clients that have had a tenant for a long time, anyone that's preceded July 1st, 2020, they probably have not had the rent cap and just cause notification signed. So when they're talking to you about extending or renewing a lease, from my perspective, I would think if you have a lease agreement that was drafted a year ago, most likely dramatic changes in law have not occurred, so you can just extend through a modification. But if the lease is dated 5-6 years ago, I would personally suggest that you draft a completely new lease agreement together with all the other addendum disclosures to be sure that we're not putting the landlord in any kind of an awkward position. And then if termination of a tenancy notice is issued and it did not comply strictly with any provision of the Tenant Protection Act, is it still an effective termination notice? And commencing April 1st, 2024, an owner's failure to comply with any provision of the just cause eviction procedures shall render the written notice void. So any questions? A lot of questions.
So if you have a tenant and they are on a 1 year, right? And then you're on that 13th month and you decide you don't want to renew, you still have to give a reason as to why you don't want to renew. Like, let's say we don't want them in there anymore.
Well, if you're not subject to the Tenant Protection Act, you don't have to give a reason.
And if
But-
you are,
But if you are,
you
then
have to be
one of those 15 reasons. So there's 11 at-fault reasons, and then 4 no-fault reasons. So if you don't meet that test, you can't terminate the tenancy. As odd as that seems. Yeah, it really does.
just check the box.
Check the box. Yeah, actually, we had somebody that contested the termination of tenancy, and the landlord had not properly provided the exemption form, as a matter of fact. So they started citing all these different reasons why the landlord cannot terminate the tenancy. It always happens. There's always somebody out there that tries to figure something out, but there are other reasons why we're able to move them out. Well, that's a good question. Anyone else? No, I think that concludes the discussion today. All right. Well, thank you, everybody, for coming.
Thank you. Have a good day.
Okay.
Thankful.
Ron. Hope it's fun. Everybody turn their cards in. Carlos went to the movies the other day.
I did.
Did you watch Michael Jackson?
I did.
Was it
Yeah,
good?
it was really good. Yeah.
Hey, Maria. Is Shrill here? I thought I saw him come in before.
He's on the phone call.
Shrill got his first listing over the weekend.
Yeah, I heard.
Yeah. It is, yeah. Hey,